All right. So just by way of introduction, I'm usually the host for these brown bag lunches, and now I'm the speaker today. So I'm doing both. So I may not have a chance to answer questions, even though you put them in the chat, because I can't see them when I'm presenting. But if you have time, I might get to some at the end. But as usual, if you type a question, someone from the audience may also be able to answer it. So ask away. And then lastly, my email will be at the last slide. And feel free to email me any questions, see if I can answer them. A little bit about myself. I'm the principal planner at Assn, which we have approximately 100 employees in 5 different regional offices. We do on-call planning services for more than 12 municipalities. We do a lot of entitlements, CEQA, NEPA for private and public developments, and we have a full biology and restoration team. So I also teach the senior level CEQA NEPA class at Cal Poly Humboldt, and North Coast board member of the San Francisco Bay Area AEP chapter, and I've lived in Humboldt County for 43 years, and I do love the outdoors and have quite a collection. So in the last few years, we've also been involved in helping bring 1,000 targeted income housing units online, everywhere from Bakersfield and San Jose up to the city of Eureka for homeless veteran housing. And we also were involved in completing the EIR for the removal of the 3 dams on the Klamath River. A little bit about that. A few more disclaimers. Again, views expressed here not necessarily those of APA or AEP. Nothing presented here is meant to offer legal advice. I just want to give credit. A lot of the material here comes from a number of dedicated CEQA folks and sources that are found on the internet and others. I don't want to take credit for their work. I just kind of pulled things together and giving you some of my opinions. And did I mention that nothing presented here is meant to offer legal advice? So what I hope to cover today is a little bit about AEP and then get into the 2021 CEQA case law. Some of the cases, some of the legislation, and some of the proposed legislation that is getting worked through the process today, and then some CEQA tools. If I go longer than an hour, feel free to drop off after that if you need to, but I'll also stick around. So a little bit about AEP. Again, started shortly after CEQA was passed, nonprofit. Really focusing on California Environmental Quality Act and best practices. So again, individual membership is only $150 a year, and we are currently offering free student members. So if you know of any, I think they're full-time student requirement, and there's the website there. So I did want to say that if you've ever had a dream about a CEQA project you were working on, maybe woke up in a cold sweat, then you should consider being a member of AEP, and then you're living the dream. It's a statewide organization with 9 chapters to represent you. There's regular CEQA trainings to improve your professional practice. There's case law updates, and our legislative committee lobbies to encourage good CEQA legislation and opposes the often made bad ideas. So just again, some more benefits of being in there. If you attend the trainings, the discounts more than cover the membership fees. So they also publish a CEQA book every year. I know some of you probably still get the CELSOC. One of the advantages of this book is it includes all the CEQA case law and legislation that was passed related to CEQA. So it's quite a book. And then as a member, they have the PDF that you can download of this book, and it is searchable and you can cut and paste from it. So lots of advantages. You can buy this book separate if you're not a member as well, but you get a free copy every year as you're a member. Next April's state conference is in Lake Tahoe. Registration is open. And I was going to say, call for presentations through the summer. If you have an interesting presentation idea, I'd be happy to further discuss it with you. Just email me. So I wanted to go to the AEP website and look at the tab here called CEQA Portal. This one is currently available whether you're a member or not. So I'm just going to briefly touch upon last year's case law and in some very simplified terms, but the AEP book lists those cases, and the CEQA portal is somewhere where you can get more information on these and the other cases that I won't be covering. So just going back, there is the CEQA topic papers and there's the case law database. On the CEQA topic papers, you can kind of see some of the topics that are there. I'll later on mention the one on alternatives, which was done a few years ago. And there's a couple others that are coming forward soon, but it's a good resource. And then also remember on the OPR site, they have their technical advisories as well. But going to the case law database, this is a topic or court or date. You could choose any of them. In this instance, I chose cultural and historic resources. So selecting that topic, there were 19 court cases that came up that addressed that. When I looked at alternatives, they had 79 court cases listed. And so going to cultural and historic resources, here's the 19. Note that you have the decision as a PDF. You can grab the summary, and in some cases, the actual CEQA document has been uploaded. So again, go to the AEP website, try it out for free, and someday it'll be locked for members only, but you can take advantage of it now. So here's the list of 2021 CEQA case law. Again, this case law is something that has a case that has gone beyond the trial court or superior court and has either gone to the appellate court or the California Supreme Court or the US Supreme Court. So I'm going to be covering the ones in blue, but just know that, like for exemptions, there were 3 court cases. For mitigated neg decks, there were 3. For EIRs, I think there are 12 or so. I'm going to go over to the ones in blue. And I'm actually, because I'm bringing in some 2022 legislation, I dropped out these last 2, the Sierra Watch and the Save Berkeley. But anyway, I really wanted to focus on how does this affect rural areas and how should my practice of CEQA change as a result of these published cases. So jumping right into our exemptions, I'm going to cover these 2 exemption cases. So the first project involved was in the city of Tustin. It was an existing Costco within the city of Tustin. Basically, they wanted to add a gas station. They used the infill development categorical exemption. And if what that exemption requires is that the project development occurs on a project site of no more than 5 acres. And often the question comes up, what is a project site? So the petitioners alleged that the project was greater than 5 acres because the initial documents described the site as 12 acres. And the other concern they brought up was that there were unusual circumstances, which was an exception, not an exemption. But so again, the question with 15.332 is what is a project site? So the court upheld the city's use of this, and the court clarified that the 5-acre maximum project site requirement, that even though the project property was 12 acres, the area of work to be disturbed was only 2.38 acres. So, and that there was substantial evidence included in this categorical exemption to support why the 2.38 acres was the project site used for this project. So, so we're talking about the area the project takes up, the area of work, not the parcel size. So that should be good news for people wanting to use this exemption. In regards to unusual circumstances, again, this is an exception that invalidates the use of categorical exemption, and the court here seemed to focus on the size of the project and the neighborhood compatibility. I think, again, this is adding a gas station. This is in an urban area that has a small shopping mall that had a number of uses. Most people would have thought that this should have been categorically exempt. But I think what this really says is the city supported the use of a categorical exemption. So they had some substantial evidence written why it did not, why there were no unusual circumstances or any of the other exceptions. So there was something that the court could review. So again, in practice, it'd be good to make sure if you're going to use a categorical exemption to document why it meets that requirement and why the exceptions don't apply. So go to our second case. This kind of maybe has some limited application. It's for a small diversion of water into a storage facility. But really what this is there's a statutory exemption that's being discussed here where ministerial decisions are exempt. And a lot of us may be working with housing element updates or SB2 and LEAP funding where ministerial decisions are related to providing housing. So this really starts to address how much discretion can a jurisdiction have and still call it ministerial. So the water board set up this permitting process. You basically put in your contact information, describe the diversion you want to include in the storage, and then the certification that the registrant has provided the information to California Department of Fish and Wildlife. And so you would document that you've done that and you submit a copy of any conditions imposed by CDFW. So this third bullet is probably key here. And the question I had, and I don't have the answer to this, but was CDFW's actions subject to CEQA? I'm guessing they were. There's the exemption of protection of the environment and natural resources, class 7 and 8, I believe. So with this kind of preemptive strategy, the board was able to actually create this ministerial decision, and therefore it was statutorily exempt from CEQA. So for instance, if you were trying to add a ministerial approval process for certain types of housing developments and you had objective design standards and performance measures, could you add a checklist to be filled out by the applicant, providing justification on how each of the checklist items have been satisfied, and either they pass or they fail? I think a lead agency has to be careful that they aren't using discretion in evaluating whether a project meets the requirements. So let the applicant provide the support if you're going to these ministerial approvals. Just a suggestion. We're going to move on to mitigated negative declarations. There were 3 of them. I wanted to focus on this one case. County of El Dorado. So basically it was replacement of the Newton Bridge with the new bridge. And they adopted a mitigated negative declaration, including provisions for emergency access and evacuation routes. The county did consult with emergency services and county fire about temporary access, and it was determined that it was not needed. Instead, they provided a detour that added 3 miles or 6 minutes to the trip. And construction was supposed to begin in April and be substantially done by the start of fire season so that people could drive over the bridge if there was a wildfire. So the society alleged that the bridge caused a wildfire hazard, trapping residents should a fire start. Part of the fair argument they were bringing up included opinions from professional aerial firefighters that there was not adequate evacuation strategies, and that resulted in potential significant impacts on the resident safety and emergency evacuation. So first, to note the name of the petitioners, it sounded like it was a group of people who didn't want an historic bridge by their definition replaced, but they didn't have evidence to make the fair argument that it was a historic structure. So instead of sticking to that concern, they used CEQA and made the fair argument that wildfire evacuation was the concern. And they provided experts in the field to testify that an EIR should be done on this project. So the court rejected that, saying that CEQA only applies to impacts of the project on the environment, that they failed to support a fair argument. So the layperson testimony, including wildfire fighters, was not substantial evidence, and the hazard was not enough. So they were obligated obligated to show how the project would exacerbate that hazard, and they didn't do that. So the court noted that CEQA requires a focus on project's impact on the environment, not the environment's impact on the project. The proper question was whether there was substantial evidence supporting a fair argument that the project may have a significant effect on the environment or may exacerbate existing environmental hazards. That was a quotation from the court case. Another quotation, the testimony provided by the community was focused on concerns about the existing hazards affecting their community and not on any potential impacts caused by or exacerbated by the project. Furthermore, the court reasoned that none of the commenters with wildland firefighting experience had any experience in determining, directing, or affecting evacuation routes. And if you've been in touch, you know some of the legislation being considered this year has a lot to do with how do we handle the evacuation routes with projects. We'll get to that at the end. So thought that was kind of an interesting case. 2 environmental impact report cases out of 7 cases in 2021. I'm only going to cover one that was covered in 2021, and then I found this one for 2022 that I thought was pretty interesting. So this is a fairly recent case. So on this first one, San Gabriel Mountains near Los Angeles, the Watershed Conservation Authority certified an EIR for an improvement project. It included things like new picnic areas, pedestrian trails, river access, upgrades to existing facilities, roadway parking improvements, and restoration. So, and note that roadway and parking improvements was just one of the elements of this plan, and it's kind of nested in the middle of this list of things that it worked on. So they had several public workshops during development of the project. So the purpose of this project was to fix an overuse of this recreational facility. The parking lot here, which came up as an issue, was a 48, and the existing parking lot is 48 parking spaces, and then there was additional parking alongside the road's shoulders. So 417 parking spaces in all. And so this project proposed to put boulders and signage along the roadway, which would reduce parking by 150 spaces or provide a total of 270 spaces. And that's why this court case happened. People didn't like the restrictions that were coming out as a result of this project. So the challenges at the trial court dismissed all the issues other than parking. They didn't think there was appropriate baseline data on the record. And the EIR conclusion was not supported, is what they felt. It was appealed by the Watershed Conservation Authority. Oh no, actually it was appealed by Save Our Access, and these were the 3 issues: parking reduction, limited analysis of alternatives, and conflicts with land management plans. So in the first one, the claim was that the reduced parking, and constrained public access, and the EIR kind of glossed over that effect, but the court held that there was sufficient discussion of parking. I like this quotation, that the notion that the centerpiece of the project is an intentional reduction in parking is utterly absurd. And it's not the project's impact on parking that matter, it's the impact of the project's reduced parking on the environment that matters. So the discussion there was, if you couldn't find a parking space, you'd go on to the next recreational site, or you would just, you wouldn't try to go there on Memorial Day when there was a lot of people there. So in regards to parking and its impact on the environment, there have been past court cases that found this to be an impact, but in this case, the court found in favor of the Watershed Conservation Authority that there was no environmental impact resulting from the reduced parking. In regards to alternatives, the project only examined the project and the no project alternative. That actually the project was a hybrid of 3 alternatives presented at the public workshops, and they discussed the alternatives that were considered but eliminated from full analysis. So kind of going through an alternative analysis early on and then just focusing on the proposed project and the no project alternative. So one of the quotations from the court was that no court has determined that an EIR must analyze more alternatives than just the no project alternative. So the language is a reasonable range of alternatives. This seems contrary to a few other court cases. But again, when we think about alternatives, it has to be consistent with the statement of objectives. It has to be feasible and it has to reduce a significant impact to less than significant. So there were no significant unavoidable impacts for this project noted in the EIR. And as I mentioned, OPR has and AEP has topic papers on alternatives. The other claim was, again, that there was no mandate to consider more alternatives than the no project alternative. So moving, let's see, and then lastly, with the land management plan, I think the claim the loss of parking conflicts with the plan's objectives to facilitate access to the monument. I can just think that this was taken out of conflict, and the court found that there were a balance between access and resource protection in the plan. So you do get comments, you might want to check the context of where that comment comes from. So this next case, this is the 2022 one in the city of Santa Cruz. I just want to include this case for several reasons. Now, the main issue on this was water supply. The city has an urban water management plan. There have been 9 years of drought, and some of the case had to do with how do you figure out the baseline of available water? Can you do it to your baseline before the drought, and drought is a special circumstances, or is the baseline now what resulted at is a result of the drought? So I didn't want to get into that issue, but there were some other issues that came up on this. But the court held that impacts that are less than significant with mitigation may be discussed in an initial study rather than in the EIR, as long as the EIR fulfills its purpose as an informational document. The court also noted that the EIR summarized the impacts and mitigation measures, and the EIR referenced the initial study, which was attached to the EIR as an appendix. And that two things was a result: that it sufficiently alerted the public to the environmental issues and provided readers with adequate information. So accordingly, the court determined that it was appropriate for the EIR to rely on the biological resources analysis and mitigation measures identified in the initial study. So Santa Cruz prepared an initial study. They included mitigation measures in it, but most of the discussion was in that initial study, and that initial study then focused the EIR on just the significant and unavoidable topics that need to be analyzed. So it was a focused EIR. The initial study determined what would be discussed in the EIR and supported substantial evidence why the EIR didn't cover the other topics. So, and again, this is kind of a strange thing. We don't normally do this with EIRs. Typically, we'll cover all 20 topics. But if you look at the CEQA guidelines, it does describe a process properly that a lead agency first prepares an initial study and uses that to determine the proper CEQA documents and the topics needing mitigation. So if an initial study provides a substantial evidence for a topic that results in a less than significant impact, then why do we cover it in an EIR? So it's a little bit different thinking, but it's actually, you know, oftentimes in municipalities, a project comes in and we kind of get this gut feeling that maybe we'll be able to do a mitigated deck on it, that it doesn't quite reach the EIR level, and we inform the applicant or their consultant in that. And then sometimes we regret that we're trying to take an EIR and mitigate it so it fits into the MND box. But Santa Cruz took a different attempt and was able to prepare the initial study. So the big issue that the claim was that the EIR was inadequate because the impacts were not analyzed in the EIR itself, and references did not fulfill the informational mandate. So what the claim was that if you're going to do an EIR, you have to put all your analysis of impacts and mitigation measures in the EIR. So This was a little confusing at first, but the courts did say no, that initial study helped focus the discussion of potential significant impacts in the EIR. So again, it's important that the EIR was, or that the initial study was appendicized to the EIR. So there seems to be an opportunity to focus things. You do initial study first, and the court seemed to disagree that everything had to be in the EIR, just the analysis of the potential significant impacts, as long as the initial study covered everything else. There were several objectives, statement of objectives that referred to the type of housing it was going to be. And they considered several alternatives with just the reduced number of units. And the claim was that the objectives were too narrow and the descriptors were too vague. But the court disagreed, and the EIR's evaluation alternatives were reasonable and supported. And the court is quoted as saying that rejecting or approving an alternative is a decision only for the decision makers, and they may reject alternatives that are undesirable for policy reasons or fail to meet project objectives. So a lot to hear more about this. It'll be interesting how people will start to apply this. Again, this is a 2022 case law, but I just wanted to end on this case because it seems the court understood and supported the lead agency approach, which doesn't always occur. And the lead agencies seem to do CEQA right in this instance. And again, most of these court cases this year seems that the court supported lead agencies for the most part. And anyway, that seemed like a breath of fresh air. So those are the court cases I wanted to cover. There, that one thing about the Berkeley, if you're familiar with the Preservation Berkeley neighbors versus basically UC Berkeley, they had a housing project. They had exceeded their attendance at the university by 5 times, and they had this housing project. They used the current enrollment as their baseline, but the one and that case failed, but then the legislation stepped in and approved the 3,000 new students this fall. But I think one of the things that was pointed out in that case was there was a difference between lead agencies that regulated land use. So most cities and counties that don't actually own the property, but they're processing application. It seemed to say that if you own the property, you had more control on using your own regulations or other state regulations that to help define whether that things would have an impact or not. So I haven't heard that before, but it seems to make sense. So let's just jump into some 2021 draft legislation. Most of this became effective January 1st. This was just a quick summary. A lot had to do with housing. So SB 9, again, you can put a duplex on your house and you can split, or on your property, and you can split your property and bypass the CEQA process. SB 10 exempts CEQA from local ordinance to zone parcels up to 10 residential units if near transit rich or urban infill areas. AB 140 created a CEQA exemption for housing targeted at homelessness. And AB 819 digitizes the CEQA notice processing. And SB 7 extends litigation streamlining for certain environmental leadership projects. So there were some limitations, but if you meet these requirements or the limitations, then the litigation streamlining is implemented, and several projects. This is also being considered for this year to expand the types of projects that could fall under that. So we'll look at a couple of ones. One that I didn't list was the statutory exemption for restoration projects. This is kind of amazing to me. I didn't know anything about this until it became effective. So there is this statutory exemption for restoration projects. Basically, you get approval through CDFW to utilize this exemption. They used it for the Garcia Estuary Enhancement Project. And then in January, it became available throughout the state. So qualifying restoration projects, I mean, most restoration projects have these objectives. So it shouldn't be too hard to classify. We did have one project that we referred the applicant to start talking to CDFW to see if they qualified. And you can have public access and limited recreation as incidental public benefits. So it doesn't have to be all restoration. And the process is, again, I love this, that you make a request, it goes through CDFW's cutting green tape, regional staff for review. Eventually would be transmitted to the CDFW director, and then it's posted on the CDFW's CEQA notices and documents page. And so that is their CEQA statutory exemption taken care of. So kind of what is interesting about this project, I would say that CDFW probably had involvement in the design and the review. So it wasn't something that came up last minute, but the lead agency submitted this on December 20th, and it got the concurrence by CDFW 1 week later over the holidays, which is pretty amazing. Like I said, I think bringing CDFW early into restoration projects might get you better qualified for this process. The second Senate Bill 156 was a categorical exemption for certain broadband. I think it's categorical exemption, but if there's 10,000 miles statewide open access middle mile network, they call it, and if your project is along or within 30 feet of a public right of way, and you incorporate measures to avoid environmental impacts, I'm starting to think this might be more of a statutory exemption, but here's the map showing the 10,000 miles. So I know there was one project talking about bringing broadband up to Hoopa on Highway 96, and it is included in this map. So what does that mean? Is it exempt from CEQA? So you might note this map and broadband projects that are coming forward. 819, this I'm just going to very quickly, you should know what you're doing on this. If you have a website, you should be filing all your documents on your website. The one notice here is your notices of exemption. So for Humboldt County, what we have to do, it's at the fifth floor of the courthouse. You have to go through security, you have to go up, take 2 elevators, and then the clipboard is behind the door in the recorder's office. And so if you file notice of exemption in Humboldt County, it's very hard for the public to really see that. But now that you're putting these on your website, they will be more available for the public to take notice of those things. So the interesting requirement. The other is that submitting the documents to the state clearinghouse electronically. One of the things I did want to mention on this, so you probably are aware that state agencies are all supposed to have ADA accessible documents posted. If you go to the OPR website, they have a disclaimer, so they're not responsible to make sure that your CEQA documents are all ADA accessible, and so that makes the local agencies, I'm guessing these would be like third-party lawsuits, or a reason if you didn't like the project that you could say that it was not accessible, and that would be a reason to reject the project. So we do this kind of, I think it's reduction, I want to call it, but it's actually time consuming. You know, it could add $5,000 to the cost of a document, especially if you have attachments that are done by sub-consultants who haven't made them ADA accessible. So keep in mind what these types of requirements might have you doing. So again, just some more of AB 19. A couple things on the 2021 legislation. This was a slide I had on last year. There were 6 cases that were put through in 2020, and they were all repeated in 2021. Only 2 got signed in 2021. And so the other four, in one form or another, are probably going to show up in 2022. So again, the legislature was busy on COVID things and limited, so a lot of bills did not get passed, but they're being carried through. So anyway, that's what I have on the 2021 CEQA legislation. I want to introduce some 2022 draft legislation. So some interesting things occurred. As I mentioned in the UC Berkeley case, there is SB 118 being introduced, passed and signed already. That's right. This is what reversed the court's decision. But it was finding that increases in population itself is not necessarily a project. So in this case, it was student enrollment. And that it provided an 18-month delay for any future decision by court to enjoin enrollment increases pursuant to CEQA. So this happened again in a very short period. It was typically bills start on January 1st, but budget bills can happen right away. And there was I think they provided $40,000 to UC Berkeley, which put it through the budget committees, and it was able to be implemented right away. So, as I mentioned, the lead agency seems, because of the court case, the lead agency has more discretion and oversight on their own projects and may be able to reference more regulatory standards and adherence to its own regulations than a private project approved by the lead agency. SB 886 would exempt CEQA's certain public university housing projects, including dining and other services. So locally here, we have Cal Poly Humboldt, who is looking into a number of public or university housing and dining services. And then there's the qualifiers, as we mentioned, the SB 35 list that these projects would have to qualify for. SB 922 would expand the existing CEQA exemptions that were created in 2019. So this was in section, this is the class 1, the 15301 section C. So there was language that if bicycle or pedestrian pathways were included in the right-of-way, that they would be exempt from CEQA. This actually expands the utilization of that exemption. And some of the limitations that you'll see. So one of the limitations that was the project could not increase car capacity and had to be located in the public right-of-way. And so this bill proposes loosening up some of those restrictions. AB 1001 requires that mitigation that compensates for air and water quality impacts to a disadvantaged community must be mitigated in that community or the affected community. So, and requires public agencies to consider the principles of environmental justice by ensuring the fair treatment and meaningful involvement of people of all races, cultures, incomes, and national organizations. So starting to get a little bit closer into the environmental justice, but on this one. AB 1642 would exempt CEQA from certain drinking water well projects, but again, has to first communicate with the state on that one. SB 1410 would limit the application of VMT for determining significance of transportation impacts only to transportation priority areas and would declare that LOS should be used elsewhere to determine significant transportation impacts. So those rural jurisdictions who lost their ability to get traffic improvement mitigation in projects, if this bill passes, we'll be back to using LOS in those instances, and VMT primarily for urban areas. Okay, SB 1369 would exempt from CEQA. An adaptive reuse project involves the conversion of commercial, industrial, public, or office buildings into housing. So you can kind of see the housing bills are still being introduced, and this would allow conversion of closed down shopping malls, for instance, could be used for housing, and it would be exempt from CEQA. This next one I thought was kind of interesting. AB 2218 would limit standing to challenge infill housing projects under CEQA to only people who reside within 20 miles. Some housing projects have been challenged by unions because they're not using professional labor agreements. So when others, anyway, just kind of interesting that limiting who can really challenge projects. Doesn't mean they can't public comment, but that gets to actually residents. AB 1154 would exempt from CEQA egress projects that the Board of Forestry has recommended for communities that should have a second access. So if you're working on a rural subdivision and CAL FIRE says you need a second egress, then that second egress would be exempt from CEQA. That one would be interesting to see how that one's applied. 2445, another one about affordable housing projects, would require anyone challenging a housing project to post a $500,000 bond to cover the developer if the lawsuit is not successful. So moving ahead on a lot of NIMBY, anti-NIMBY regulations. Another housing bill, 2656, the Housing Accountability Act, prohibiting disapprovals without making certain findings. So we're used to making findings to approve a project. Now we have to make specific findings passed by the state to disapprove a project. And if, especially denying the use of a CEQA exemption if the project is eligible, and requiring further study to adopt a negative declaration or addendum when there's legal sufficient basis in the record already. So kind of making it a little harder for people who are opposed to projects and giving tools to people who are promoting projects regarding housing. SB 6 would allow some infill housing on land zoned for office or retail commercial, and would provide funding. And see, both bills stalled last year, awaiting possible action in the Assembly in June. So current project. AB 916, prohibiting a local government from requiring a public hearing as a condition for approving a project to add a bedroom or rearrange walls within an existing home to add a bedroom. What if this involves design review? Anyway, it would also amend the ADU law, places limits on local ordinances for ADU. So this is like a minor, but this is, it's going from 16 to 18 as a maximum height to be approved. So those of you who have approved your ADU ordinances or are in the process, hold on, you might have to change the height limitation. Some wildfire bills. This would place requirements on local governments before approving projects in very high fire hazard severity zones. We would start to get these reduction standards probably in the building code and others for the design and review of projects, require cities to update the general plans and zoning. And then I like this one, reduce the RENA requirements based on your percentage of land in these very high fire hazard severity zones. That makes sense to me. Another one would prohibit a city or county from approving a new residential development located within the area unless it met a number of criteria, which is actually welcomed in that we have that criteria instead of leaving it up to each agency and the challenging public. This at least would set aside what that criteria should be, and that would vary on project size. In regards to public meetings, it looks like the ability to continue with virtual meetings. It also protects the decision maker, the legislative body, from if they do come in virtual, they don't have to invite the public into their house. Again, this hasn't been set for hearing yet. This was as of April. imagine it's moving it forward. This also about public meetings would add requirements for local governments to offer accommodations to hold remote meetings. So it looks like this hybrid thing that many of us are currently in would continue. So even if your city council is meeting back in person, to still have the opportunity for others to remote in. So, but it does require your legislative body to be present in person. I think this is our last public meeting one. Allow local government meetings agendas to be posted online instead of posting on site of the government office. Couple planning, well, one planning, we're wrapping this up. So we recast the requirement. So this one is being opposed by a lot of cities and counties. So it's affecting the transportation funding that they get. It's requiring a lot of jurisdictions to meet the sustainable community strategies, state climate goals, and limiting the types of projects. So what I've heard from rural cities is that the state doesn't understand the needs of the rural communities. And so passing this bill means you're meeting the state's needed projects, not the local projects. So that's why the opposition is coming forward on that. So regarding climate, it would require OPR to facilitate this regional climate network. So another regional department or something, making sure there are regional climate adaptation action plans. And I think I got a few more. So just a quick thing on 2022, we've already gone through the redistricting drama and seeing how it affected our re-election, or at least the primaries. We have 6 senators terming out in California, and many are retiring. And by next year, there'll be 35 new legislatures. All the statewide seats, as you saw in the primary, all were incumbents, but they all were at this last election, and lots of ballot measures that are being forwarded. This was an interesting article that I read. Is there CEQA reform going to be happening? So the assembly member who wrote an article, CEQA reform is too damn hard, is working on major CEQA reform. I think the second bullet point here is this apology from the unions saying we are really sorry about the bad CEQA cases we filed just to leverage project labor agreements. From now on, we promise to play nice. So I was in the LA Times, San Francisco Chronicle, and the Sacramento Bees. We'll see how that plays out. And then just some of the things they're considering are exemption for projects less than 10 acres in size, a repeal of the fair argument standard for neg decks, an exemption from further CEQA analysis where the state has published certain regulatory standards, and an alternative streamlined pathway for analysis based on an OPR approved methodology. So we'll see how far some of these will get, but that's kind of interesting to see this coming about. I wanted to bring attention to the OPR's technical advisory. There are CEQA exemptions outside the CEQA statute. This document includes a lot. It was last updated in 2018. There's even more, but just to know that the CEQA statute is not getting updated with everything. So typically the bill would pass changes and then basically make a statement that this is not part of the CEQA. Not subject to CEQA, it's statutory exempt or something, but it never shows up in the statute or guidelines. So just be aware that there's that technical advisory. Sometimes these are in the health and safety codes or elsewhere. I did want to also mention, you should be familiar with OPR's CEQA.net, and also the site check. So site check is a statewide database, GIS database, that you should be aware of it. I think they're still in its beta form, but they're continuing to provide resource sensitive area mapping and other sources in there. So check out site check. And here is the OPR CEQA net, and this was some of the recent postings. So again, just to check if you want examples of what's being in there. And again, they have the notices. And they also have a searchable database here for projects. This is an example of the OPR site check. You can kind of see some of the resource layers in here. Special habitat, wetlands, earthquake, floodplain, wildfire hazards. It is statewide, and it is also parcel specific, so you can zoom in and see how those layers affect your parcels. So I know many of you probably have good GIS systems that you have the same information on, but this is, we'll see where this goes in future years. So how about that? We are done. There's my email address. I do have some time for questions, and look, so if you do want to enter something into the chat or questions and answers, I'll be happy to respond.
Bob, it looks like we do have one question so far. Asking if there's something that has outside CEQA exemptions that is up to date since 2018, so that technical advisory show that was from 2018. They're wondering if there's something more recent.
Well, I did just check last week, and there was no update to those. So I was hoping there would be an update. It'd be a good source to keep updated every year. Right. Well, just want to say thank you, everybody, for attending. I know during registration, you had an opportunity to say whether you wanted to be added to our MailChimp list or not. I wish I could announce what we're doing next month, but we'll have some brown bag lunch program schedule and let you know what's happening. Locally, we're also trying to get some social programs going again, get kind of dusting off the COVID webs and getting overcoming our social awkwardness. So somebody asked about the slides. I would say this presentation is recorded on our YouTube site. You'll get a link to that so that you'll have access to all those slides there. All right, well, thank you, everybody, and we'll see you around.